Hello viewers. Welcome back to our channel, Labor Laws Official, where we strive to educate and inform you about important laws and regulations that impact our lives. In today's video, we will delve into the Protection Against Harassment of Women at the Workplace Act 2010 in Pakistan. This act plays a crucial role in safeguarding women's rights and ensuring a harassment-free work environment. Let's explore its key provisions and understand its significance. What is harassment? Harassment means any unwelcome sexual advance, request for sexual favors or other verbal or written communication or physical conduct of a sexual nature, or sexually demeaning attitudes, causing interference with work performance or creating an intimidating, hostile or offensive work environment, or the attempt to punish the complainant for refusal to comply to such a request or is made a condition for employment. The above is unacceptable behavior in the organization and at the workplace, including in any interaction or situation that is linked to official work or official activity outside the office. Key provisions of the Act. Role of Inquiry Committee. 1. Each organization shall constitute an inquiry committee within 30 days of the enactment of this Act to inquire into complaints under this Act. 2. The committee shall consist of 3 members, of whom at least 1 member shall be a woman. 1 member shall be from senior management and 1 shall be a senior representative of the employees or a senior employee where there is no CBA. 1 or more members can be co-opted from outside the organization if the organization is unable to designate 3 members from within as described above. A chairperson shall be designated from amongst them. 3. In case a complaint is made against one of the members of the inquiry committee, that member should be replaced by another for that particular case. Such member may be from within or outside the organization. 4. In case where no competent authority is designated, the organization shall within 30 days of the enactment of this Act designate a competent authority. Powers of the Inquiry Committee. The Inquiry Committee shall have power: A. To summon and enforce attendance of any person and examine him on oath. B. To require the discovery and production of any document. C. To receive evidence on affidavits, and D. To record evidence. Procedure for holding inquiry. 1. The Inquiry Committee, within 3 days of receipt of a written complaint, shall A. Communicate to the accused the charges and statement of allegations leveled against him, the formal written receipt of which will be given. B. Require the accused within 7 days from the day the charge is communicated to him to submit a written defense, and on his failure to do so without reasonable cause, the committee shall proceed ex parte, and C. Inquire into the charge and may examine such oral or documentary evidence in support of the charge or in defense of the accused as the committee may consider necessary, and each party shall be entitled to cross-examine the witnesses against him. 2. Subject to the provisions of this Act and any rules made thereunder, the Inquiry Committee shall have power to regulate its own procedure for conducting inquiry and for the fixing place and time of its sitting. 3. The following provisions inter alia shall be followed by the committee in relation to inquiry. The statements and other evidence acquired in the inquiry process shall be considered as confidential. A. An officer in an organization, if considered necessary, may be nominated to provide advice and assistance to each party. B. Both parties, the complainant and the accused, shall have the right to be represented or accompanied by a collective bargaining agent representative, a friend or a colleague. C. Adverse action shall not be taken against the complainant or the witnesses. D. The Inquiry Committee shall ensure that the employer or accused shall in no case create any hostile environment for the complainant so as to pressurize her from freely pursuing her complaint, and E. The Inquiry Committee shall give its findings in writing by recording reasons thereof. Penalties and consequences. The Inquiry Committee shall submit its findings and recommendations to the competent authority within 30 days of the initiation of inquiry. If the Inquiry Committee finds the accused to be guilty, it shall recommend to the competent authority for imposing one or more of the following penalties. Minor penalties. A. Censure. B. Withholding, for a specific period, promotion or increment. C. Stoppage, for a specific period, at an efficiency bar in the time scale, otherwise than for unfitness to cross such bar, and d. Recovery of the compensation payable to the complainant from pay or any other source of the accused. Major penalties. A. Reduction to a lower post or time scale, or to a lower stage in a time scale. B. Compulsory retirement. C. Removal from service. D. Dismissal from service, and E. Fine. A part of the fine can be used as compensation for the complainant. In case of the owner, the fine shall be payable to the complainant. 5. The competent authority shall impose the penalty recommended by the Inquiry Committee within 1 week of the receipt of the recommendations of the Inquiry Committee. 6. The Inquiry Committee shall meet on regular basis and monitor the situation regularly until they are satisfied that their recommendations subject to decision, if any of competent authority and appellate authority have been implemented. 7. In case the complainant is in trauma, the organization will arrange for psychosocial counseling or medical treatment and for additional medical leave. 8. The organization may also offer compensation to the complainant in case of any damages. Ombudsman to inquire into complaint. 1. Any employee shall have the option to prefer a complaint either to the Ombudsman or the Inquiry Committee. 2. The Ombudsman shall within 3 days of receiving a complaint issue a written show cause notice to the accused. The accused, after the receipt of written notice, shall submit written defense to the Ombudsman within 5 days, and his failure to do so without reasonable cause the Ombudsman may proceed ex parte. Both the parties can represent themselves before the Ombudsman. 3. The Ombudsman shall conduct an inquiry into the matter according to the rules made under this Act and conduct proceedings as the Ombudsman deems proper. 4. For the purposes of an investigation under this Act, the Ombudsman may require any office or member of an organization concerned to furnish any information or to produce any document which in the opinion of the Ombudsman is relevant and helpful in the conduct of the investigation. 5. The Ombudsman shall record his decision and inform both parties and the management of the concerned organization for implementation of the orders. Responsibility of employer. 1. It shall be the responsibility of the employer to ensure implementation of this Act, including but not limited to incorporate the Code of Conduct for protection against harassment at the workplace as a part of their management policy, and to form inquiry committee and designate a competent authority. 2. The management shall display copies of the code in English as well as in language understood by the majority of employees, a conspicuous place in the organization and the workplace within 6 months of the commencement of this Act. 3. On failure of an employer to comply with the provisions of this section, any employee of an organization may file a petition before the district court. And on having been found guilty, the employer shall be liable to fine which may extend to 100,000 rupees but shall not be less than 25,000 rupees. That's all for today's video on the Harassment of Women at the Workplace Act of 2010 in Pakistan. This act is a significant step toward ensuring a safe and inclusive work environment for women. By addressing and preventing harassment, it protects women's rights and promotes gender equality in the workforce. If you found this video informative, please like and share it. Don't forget to subscribe to our channel for more content on important laws and regulations.